I can see Susan is online already. This is not the tea break, so there's another panel. Just sit there. And this is going to be also super interesting. So I'll start with the introduction while the team sits down. I don't see Pierre. Is Pierre around? Jamie, is Pierre around? No, you haven't seen it. Oh, my dear. Very good. I was asking. Okay, so everyone, this is a panel about challenges of merger control. We've talked about all sorts of things already, but this is going to be focused in particular. Hello? Okay. This is going to be focused in particular on merger control. We have a number of speakers who are going to focus on slightly different angles in this discussion. We have no less than three chief economists, Pierre, Aviv, and Susan on the call, so we are particularly privileged. We have star economists like Chiara, and of course, a star regulator like Sarah. But I want to start, actually, this discussion with Bruno Pellegrino, University of Maryland. And Bruno is so apt in terms of the discussion we are having today, because he is, just briefly, an IO economist, IO-trained economist, who has come to look at the questions that we are facing here by trying to marry traditional IO with a broader macro lens. And this is important because, given all we heard today, it is notable that, and Bruno will tell us more about it, macroeconomists are taking an interest in what's happening at the level of concentration in markets and are asking what is going on over there. We can begin to see the effects of this growing concentration at the macro level. And so it is incredibly important that there is a new generation of economists like Bruno who are actually not siloed, not churchy, and want to just interface with these other disciplines like macro to try and bring forward these greater insights. So Bruno, please take it away and give us a bit of insight.
Can you hear me? Oh, first of all, thanks a lot, Christina, for the very kind introduction. So I want to start by sort of like rephrasing, okay, a little bit the question here. So this is a panel about merger control. And so what are the questions in some sense that we have to answer today? One, did the economic environment change in a way that suggests that we should change the way that we tackle merger control? One. Two, if that's the case, what should we do different from a merger control point of view? I'm not going to address the second question because we have some exceptional experts on enforcement, but I think what my research can speak to is actually the first question is, did the environment change? And I'm going to make the argument that indeed the environment has changed in a pretty significant way. Now, as you mentioned, where I'm coming from, this is from this hybrid IO macro angle. Why does this angle, I argue, can help this discussion? The reason is that if we're trying to figure out whether we're doing merger control right, it's not sufficient to look at evidence from a single industry. We have to see what's happening across many different sectors, okay? Now, traditionally, my IO colleagues have been shying away from multi-industry studies, and I think for a very good reason. When we, everybody here in this room probably is familiar with how difficult it is sometimes to define even a single market, and how many antitrust litigation are, in some sense, decided by market definition. Now, when we blow, in some sense, our picture from micro to macro, we face the seemingly impossible challenge of having to define a multitude of markets all at the same time, and we have to do that objectively and systematically. So how do we even start making progress on a problem like that? So basically, and this is a problem because in some sense, anything that you can show about markups, concentration, all of the great work that Jan and John have been doing, comes under scrutiny and people can criticize it just because your market definition is not right, okay? So So where my work comes in is I've been working on a different framework to think about product markets, and it's basically a network theory of market power. So the idea being we want to think about the entire product market, the entire economy, not as a collection of siloed sectors or industry. We want to think of it as a network. So a network is basically a bunch of nodes that are linked together, okay? So in this case, the nodes are products, and the links is product substitution, okay? So the idea is, how do we think in a model like this about something like concentration, okay? We think of it as a centrality, okay? So the idea is a firm that produces a good that has many potential substitutes, is a firm that has little pricing power. This is a very central firm in the network, and basically the firm is going to act more competitively. Vice versa, a firm that produces a good with few substitutes, a firm that is highly peripheral in this network of products is going to behave more like a monopolist. Now you're probably thinking, okay, this is all, fine and dandy. It's just like some other cool theory coming out of the ivory tower. In reality, there is some data out there that actually can help us estimate a model like this. I think you prepared the slide.
Do we have some slides? There is a slide for him, just one. That should come up, yeah.
Yes, so basically this is just an example of the data that I've been working with. It's basically, it comes from textual descriptions of products, and you represent basically the American economy as a network. These are actually, each dot in this diagram is a real firm. The data comes from Oberg and Phillips, and as you can see, basically we can represent it as a network. Now, what is the benefit of this approach? The benefit of taking this network approach to market power is that we do not have to define markets, okay? Here we can be completely agnostic about what a market is. And so, again, we can use centrality to measure shifts in market power, except that now, what is different with respect to all of the previous work? Now, you cannot, if you disagree with the conclusion, you can't just tell me, oh, your market definition is wrong. There is no market here. I'm basically allowing the data to speak itself.
So what's the next one?
So basically, if you want to show the next slide, here's basically we can measure use centrality to measure the market power of different firms, and we can measure it over time. And so what you can see here is the distribution of centrality. So again, lower centrality means more market power, and I think this picture speaks for itself into what has been happening in terms of market power over time. Okay, so this is sort of like the first fact that I want to contribute. So, and this basically, what's important here, this feeds directly into the share of surplus that goes to the producers as opposed to consumers. And so this is the first fact. Now, this is a session about merger control, so I want to connect this line of research to mergers. Another thing that we can do using this framework, we can look at measures that are relevant to merger analysis. We can compute diversion ratios, okay? So we can compute them for millions of firm pairs, okay? And then we can compare how do diversion ratios of merging firms compare to diversion ratios of firm pairs that do not merge. And again, what comes out very clearly from the data is that slowly but surely, over time, the distribution of diversion ratios of merging firm has been shifting more and more into the highest percentile. So basically, to give you an idea, 20 years ago, the typical merging firm pair was at the top fifth percentile of diversion ratio. Now it's in the first percentile, okay? And so I think this has to be, it has to inform how we think now, a new thinking about merger and control. So I think there is some important scope for new lines of thinking on merger and control. And so here's where I want to stop. This line of research is just starting, but let me yield the floor to...
So I wanted people to be aware that this research is going on because it is the case that economists need to do frontier work. And this is frontier work, which is going to be the future, which is going to be interesting. Looking across sectors is important. We cannot continue to do things market by market. Of course, in the everyday practice of antitrust, we know that that's what we do. So I wanted to move on to Aviv, who has been recently confirmed as the chief economist at the FTC. And Aviv, what is inevitable and what is difficult to overlook is the fact that we are seeing, you come into enforcement, you've been there before, but you come into enforcement at the FTC at a time when the demand for new ideas and expression of theories of harm is high. Okay, on the part of regulators, there is a need to cater for conduct and mergers in particular that with dimensions we haven't seen before. So we see a rise of conglomerate theories, they've always been there, but there's more demand for them. There is ecosystem theories and so on. So economists tend to say, well, you know, unless you show me the precise leveraging mechanisms from here to there, I don't really know what you're telling me and so on. So what is it that you think about this? And more generally, you come into it at a time when the role of economists is questioned for all the reasons we heard also this morning. So why don't you give us a few thoughts on that?
Okay, well, thank you. First, thank you for having me here. I believe I was here about 8 years ago at this conference, and I can say two things have changed. First, the whole tone of the conference is completely different, maybe not surprisingly, and that's a good thing. The other thing is we used to have the stage, or at least that time the stage was over there on the side, kind of horizontal. It was a vertical room instead of a horizontal room. So that was one big change. But in terms of the intellectual engagement, it stayed equally at high quality. So thank you very much for having me here. Before starting, let me just have a quick disclaimer. What I'm about to say might or might not represent my own views, but it definitely does not necessarily represent the views of the Commission, the Federal Trade Commission, or any individual commissioner. Okay, so with that out of the way, let me just start a little bit of background and then go directly at Christina's question. So many economists you could put into sort of, I would say, two main buckets. One, which we haven't seen here today, and it's not randomly so, I think by design, are those that say, you know, the issue is kind of greatly, the problems are greatly exaggerated. You know, everything, yeah, maybe we can think things at the margins, but there's really not that big of a problem, okay? And then there are those that we saw, you know, throughout today, Tommaso earlier, the previous panel, that are calling what my Yiddish grandma would call Gewalt. If you don't know what Gewalt means, look it up at Google in a second. But it's basically disaster, you know, help, problem, okay? But in reality, are not offering much in terms of immediate help, okay? So, you know, Bruno's example, great. You know, I love that figure, but I can just imagine the next time we have someone coming in and saying, hey, we told you, everyone's in the market, right? We'll compete with everyone, right? Bruno said so, look at his map, right? So, you know, it's great to have that as a guiding light. It's great to talk about we need, you know, a global antitrust enforcer. I volunteer to be the chief economist for that enforcer, if I'm still, you know, able to walk on my own at that time. It's great to say we need new rules, we need legislation, but that ain't happening anytime soon. Okay, I mean, let's be realistic about it. So that leaves, I'd say, a third group, which, you know, we have three of us on here on the stage, that are those that are actually working in the trenches and actually trying to figure out what the heck are we going to be doing, okay? And we need to make progress, and we need to make progress somehow because it's very clear that we need to push the frontier in several ways. So let me comment on a few things that have been said today. And let me just say one thing, kind of respond, and I'll go through in detail. So something Tommaso said of, oh, you know, we really need, you know, simple models, robust models that are easy to explain. It's a little bit like me saying, I wish I was 10 centimeters taller, 20 years younger, and had more hair. Neither one is going to happen immediately. The world is complicated. We like it or not, that's the fact. And I wish I could summarize it in a very simple, robust model that would convince anyone just upon hearing that, okay? But again, there's a lot of other things that I wish, and I've already admitted I'm not going to get them. Okay, so we need to be real. Yeah, Pierre, it's yeah. Be careful. So that's so what, you know, where do we go? What is it that we actually do instead of sort of saying, hey, you know, we give up, nothing can be done, because we do have to do something. So let me first start with, there was a little bit of a tone, I think, early on, as like, well, we got too much economics. Okay, that's wrong. Okay? We don't need sort of less economics, we actually need more economics. Okay? But what we need is more economics in the sense of being wider, right? Not focusing on narrow. You know, previous panel used kind of, you know, Chicago School of Economics. I don't know, the labeling here sort of helps. The idea is we need to look at sort of a wider set of theories, not sort of characterize economics as being, hey, all we care about is price effects in the short term, okay? That's not what we care about, right? When we talk about consumer welfare standard, that is a mischaracterization of what it is, right? Consumer welfare allows for change in variety, allows for change in quality, allows for innovation by looking at kind of long-term effect, and frankly could even allow for looking at different subgroups of the market and not putting equal weight on everyone, right? I mean, just go back to, you know, anyone here that's taking a first-year micro class will know that that's the fact. And this is not necessarily new economics. I mean, this is old economics that's been around for a very long time. So we have to be careful about not mischaracterizing what economics, and I think our job is to push back on that as economists and saying, no, you cannot take that narrow view. You got to take a wider view of economics and a more modern view of economics that includes a lot of the principles that were talked here as kind of abstract. Economics can accommodate all of those, okay? And it's important to sort of do that because we need economics to kind of help organize our thinking, okay? We actually heard that a little bit earlier today. We have a huge task in front of us. If anyone thinks that they can do it without economics, well, they got to check, you know, they got to replace the bottle of water that they're drinking because there's something funny in it, okay? You will not be able to do that, okay? You need to work, economists, together with lawyers, maybe together with other disciplines, technologists, and so forth, to get that together. And if you want, you could just look at examples from the US in the past, right? Whether you want to look at what happened in hospital mergers, where the agencies, you know, consistently lost, I mean, I heard once 15 cases in a row on hospital mergers until they sat back and said, what is it that we can change? And they came back with a new economic framework, okay? And then went on a very long winning streak that just ended, you know, fairly recently. Okay, so it's that kind of thinking of bringing in new, modernized thinking that, you know, that's attached, as Jonathan said, you know, earlier, to the market realities. That is what we need. Okay, not less, but more. But not just more in terms of quantity. We need the right kind of economics.
Oh, exactly.
Okay? Going back, you know, people like to criticize, you know, the Obama administration is not doing stuff, but, you know, we were pushing the frontier. I mean, there was a merger between Comcast and Time Warner that everyone said, you can't challenge because they don't overlap, right? They don't overlap geographically, so there's nothing here to challenge in a merger. Well, guess what? We put it through the lens of bargaining theory, and next thing you know, it was challenged and, you know, with the help of the FCC, actually never materialized. Okay, so that's another example of how we bring modern economic theory to sort of think, what is it that bothers? How do we kind of think about a lessening of competition in a broader sense? Okay, so that's the first thing. Again, just to summarize, more economics, not less. The other thing I want to touch on, and again, we touched on it a little bit earlier, is the role of theory versus empirical work. So historically, a lot of what was used, the economics that was used in antitrust, was mostly based on theory. Partly kind of following the field of industrial organization that was historically, and we're talking now quite a long time ago, was mostly theoretical. But that's changed. It's now an empirical field. Now, it's true that a lot of what we do is, you know, complicated, sophisticated models that I myself would admit are not necessarily ready to be put in front of a judge, and maybe will never be. Okay? But they do deliver insights that we can take. And it's important to take those insights. Because if you look at cases that we lose, that the agencies lose, it's rarely on the theory. Okay? I mean, John talked earlier about the meta within case. The judge accepted the theory. Okay? Where we unfortunately lost was the judge said, I don't have the facts to support that theory. It's not that he did not believe the theory, okay? It was needed the facts. Okay? Now, where are facts going to come from? If we have documents, that's great. If we have customers or industry participants that are willing to testify, that's great. Okay? When we have data, we should be able to use it. And I think that's a major role for economics. So we can't just be just about, let's formulate a simple theory that lets us think through the theory of harm, as we articulated earlier. We also need to bring in the pieces, the facts, to convince whoever the fact finder is, a judge, a jury, a decision maker and a regulator that the theory is relevant, because there's always going to be a theory from the other side, right? As kind of Jan said earlier, we're not regulating or we're not litigating in a vacuum. We actually have someone from the other side that's going to have very smart people coming up with, what was the term you used earlier? I forget.
Exculpatory narratives.
Yeah, you could call it whatever you want, but they're going to push stuff that, has at least some merit to it. So we need the empirical evidence and the facts to convince that our narrative is the correct one, okay? Because just as a matter of theory, we're not going to be able to win. So that's kind of the second point. And then finally, let me call a little bit of I call it a call to arms. So it's great to have folks sitting up here and kind of making, big claims about everything that's not working well, and we need this and we need that. But what we also need is we need folks that are willing to come and fight and work in the trenches. And it's dirty work, okay? It's literally, street combat, okay? So you got to take off your, fancy Italian suits, okay? Put on your work overalls, your boots, and come and get dirty, okay? Because it's not just about creating fancy graphs or fancy theories. It's about getting and fighting literally, block to block, and getting it done. So we need your help. Come and do that if you're willing. Thank you.
Thank you. So I want to resist a little bit, though, Aviv, this idea that what happened here today was an all-out fight against economics. I mean, I had a panel of 10 economists, and I have many through the day. You are in the trenches. I'm in the trenches, too. I've been there for 25 years, and I've seen it. I know where all the bodies are buried. And the point is that I think much of what is the economics that is done in cases is not worth it. It's not good, it's not worth it. On a daily basis, what is submitted, what is discussed is low level, is glorified market share, some kind of simplified stuff, and I'm as guilty as the next person. That's what the economic profession, the consulting profession, you've also been exposed to it, that's what it does. And so it's not a resistance to economics in general, but you are right to say the question is we need to do the right economics. We need to think about how to make it useful in a way that is more informative than what is done in many cases today, because I ain't got very much time for what is done in many cases today. And I put it on the side of certainly the profession I'm here to represent. Now, talking about this, Chiara, one of the things that has come to the fore, one of these kind of insights that we need to bring forward more, that wasn't really in the toolbox, but is now becoming much more popular and much more capturing attention, is this idea of potential competition, killer acquisition, the role of it. I remember very well 15 years ago in which we didn't care about potential competition in cases. I was with a chief economist at the time who shall not be named, but was saying to me, unless somebody is in the market, potential competition, I don't care. Okay? So this was the view that we came from, and now we are moving to a different view. And so you've been doing research in this area. Talk to us about that. Thanks.
Yes. First of all, thank you very much for involving me in this great initiative. Really, thank you. And yes, I would like to first start my discussion making the following point. When we talk about this issue of how merger control can deal with acquisition of nascent competitors, the debate has focused a lot on killer acquisitions, on the idea that, okay, there are these acquisitions, upon the acquisition, the project of the target will be discontinued. So an innovation that could be developed and could become a new product or a new technology which compete with the acquirer's core business. So the idea is that will be discontinued because of cannibalization of the acquirer profits. What I would like to stress is that it's not only, so a competitive concern, a competitive harm may arise not only because of killer acquisitions. There is much more than that. Competitive harm can arise also because suppression of competition. because even if the target innovation is not discontinued, the acquisition may still reduce dramatically competition if the target has the capability to become an aggressive, an effective competitor in the future absent the acquisition. And secondly, it's also the case that this kind of acquisition may discourage the acquirer from developing a new business internally that could compete in the absence of the acquisition with the target business in the future, the so-called reverse killer acquisition. So I would like to make this point because there is much more concern beyond the simple or killer acquisition. First. Second, however, I would also like to stress that these acquisitions do not only have dark sides, they may have also bright sides because the acquirer may have critical resources that instead the target may lack, resources that are critical for the success of the target project, such as implementation skills, managerial skills, financial resources. And therefore, this type of acquisition may also may facilitate new products or new technology in reaching final markets, in reaching consumers and users. And this might not happen without the acquisition. So the point is, what can we do in order to distinguish between these two types of acquisitions? Those that may deprive society of innovation and competition, and those that instead may help society in enjoying this innovation. I'm relying on ongoing research that I'm doing with my co-authors, Massimo Motta and Emanuele Tarantino, in which the point that we want to make is that the value of the transaction can convey critical information in order to distinguish between these two types of acquisitions. The idea is that what we show is that a high price suggests that there are high chances that the acquisition is not indispensable for the success of the target, and therefore that there are high chances that that acquisition is creating a competitive harm. And the basic idea is very simple. The idea is that if the target is likely to struggle to survive without the acquisition, why is the acquirer willing to pay such a high price? So the point is, but in practice, how can we use the information conveyed by the price in order to improve enforcement? So a first implication is that we might use transaction values in order to alleviate the problem that has been mentioned so far, the problem that this type of acquisitions typically escape merger control because the target has not produced enough revenues yet to trigger notification. But so this simply suggests that we might want to introduce thresholds that are based also not only on turnover but also on transaction values. And this has been done for notification. And this has been done, for instance, in Germany, has been done in Austria. The threshold already exists in the US. It's $101 million for notification. Instead, this has not been done in the European Union, for instance. It's true that in the European Union there is Article 22 that helps remedying the difficulties, the deficiencies of a system based on the threshold on turnover. But what is not clear to me is why a system based on, let's say, discretionary referral by national competition authorities rather than a system based on transaction value, which is more transparent, a little bit more systematic. Then, of course, this is not enough, and there are no magical numbers that can tell you how to set these thresholds, and it's also likely that if there are these thresholds for notification based on transaction values, and competition authorities receive a lot of notifications, so how to decide on which ones we want to investigate better. But again, the value of the transaction can be a useful tool in this respect. In our research, we show how one can use accessible data to build a set of comparables, acquisitions that are sufficiently comparable to the one that you are examining, and you can build statistics that help you have a sense on when a price is high. Of course, I'm not saying that this should be a rule which prohibits, it's not a magical box that tells you, okay, this acquisition needs to be prohibited or this should be authorized. But you can have a sense of which are the ones that are likely to raise more concerns and therefore should be investigated more carefully, or you may decide to give a presumption of harm. But this can be done in an informed way. It's not necessarily the case that we have to navigate in the dark. And the information conveyed by the value of the transaction can also help us identifying what is the proper counterfactual to the acquisition, which is what is difficult when you have acquisition of potential competitors, and make the exercise less speculative, less uncertain. So said that, and therefore, the point I want to make is really the value of the transaction can be an important tool. Of course, an issue that remains and that is crucial is what is the standard of proof that we want to apply, that courts or agencies should apply in assessing this type of acquisitions. Because what we hear very often is that, okay, you can also notify everything. But then, if we have to demonstrate certain harm, it's very difficult, so it's completely useless. But on the other hand, the CMA decision and the cut judgment on the CMA decision on Facebook Giphy also suggests that there is scope to make a decision based on potential harm rather than certain harm. Okay. So the question that I also would like to ask to the rest of the panel is, are we ready are we fine with potential harm in judging this type of acquisitions? And let me just conclude, this question for me relates to another point that is not only important for acquisition of potential competitors, it's important for merger control in general and also for abuse of dominance. So the point is, the way I see it is that antitrust intervention is very much designed to minimize the risk of over-enforcement. But probably we should ask ourselves, is it's not the time to be more concerned about the risk of under-enforcement?
Well, I think that time has passed. I mean, we are very concerned about under-enforcement.
Yeah, but
and I think it is certainly a question that I think is settled at this point, at least from my perspective. So you mentioned Meta Giphy. I want to then also, of course, talk to Sarah, who is the senior regulator on this panel, head of agency. But before I do that, I want to just quickly speak to the other two chief economists. I see Susan, who's been also waiting patiently over there. I mean, many issues that you could talk to us about, Susan. One of the things that I know that you can't talk about explicitly because the new merger guidelines are not yet issued is what you would like to see as an economist and as a chief economist in these forthcoming guidelines, not with any sort of detail, but to give us a sense. To me, a lot of what we do when we're talking about mergers, particularly in digital, is somewhat beside the point. We try and measure power by measuring market shares, and this is telling almost nothing when we are really talking about combining assets and capabilities when you're talking about mergers. But I realize it's difficult to measure those. But anyway, do take it away. We are looking forward to hearing you.
Great. Is the audio all right there?
Yeah. Yeah.
Great. Thanks so much. Well, thank you so much for organizing this invigorating, necessary conference. And I'm so sorry that I wasn't able to be there in person. Clearly, I'm missing out. On the guidelines, just as you said, I want to make clear that I can't say anything specific about the guidelines or our development process or when they'll be released, but I can share some of our thinking about why it's so important we undertake the project. Maybe just to start with, I want to echo what Aviv said. I think he raised a really important theme about just how important good economics is to modern antitrust enforcement. And certainly that's been my experience in the antitrust division. The problems we're facing are really complicated, and modern economic thinking is crucial to our success to understand what's going on and protect competition in the most effective way. Getting the economics right in a way that really captures the essence of competition in a particular setting, that's what allows you to frame an investigation smartly, to identify the competition and to communicate a coherent framework that organizes the facts and evidence and makes it intuitively clear how a merger or particular conduct might threaten competition or deter entry. So overly simplified economics can confuse you away from what might be intuitively obvious, but modern economics can really align with common sense intuition. And so that theme of understanding competition as how it presents itself really infuses our approach to the guidelines. Just, at the very core, mergers are supposed to be illegal if they lessen competition. And so a lot of it comes down to what competition means. And the modern economy, that can present in complex ways. Maybe things never really were that simple, but decades ago, it might have been more common that mergers were either just among firms that sold, directly competing products, or among firms in a vertical supply chain where there was a manufacturer and a distributor, or one firm manufacturing input to a production process. But today, we see these acquisitions by firms that sell lots and lots of products that are interrelated in much more complex ways. And the harm to competition might take more complex forms. But modern economic thinking and antitrust concepts are up to the task. Yet we need to make sure that it's clear how these concepts apply to these more and more commonly encountered fact patterns. For example, a merger might harm competition by increasing barriers to entry, like creating the potential to use one product to influence the purchasing behavior of consumers on adjacent products. A merger might let you get exclusive access of some asset like data, or combine data in unique ways that can raise barriers to entry. A merger might be motivated by blocking a nascent competitor that today competes narrowly, but if it gets a toehold, could grow into a more full-fledged competitor if it succeeds at first in a niche. Merger can concern two firms who compete head-to-head in innovation on products that don't yet exist, as we were just discussing. It can affect competition in input markets, and so on. And within the agencies, when we see a merger come before us, a really important starting point is just to get back to first principles and ask, how does competition present itself here? More specifically, what are the threats to that competition? What strategies would an entrant or challenger need to use to get a toehold or to grow? And how could those be thwarted? So what are the dimensions of competition? What are the tactics that really matter in this industry? That's a key approach to thinking about our cases, and the guidelines revisions can help us better align with this approach of focusing on the first principles of competition. So what does that mean in practice? One element can be recognizing common fact patterns and spelling out clearly how we interpret the potential for harm to competition when we encounter those patterns. It might be being more clear how we think about things like platform markets. Jonathan talked about that. I don't want to, and lots of others, I don't want to repeat, but in short, of course, platform markets can present complexities. They come in different forms. They can depend on factors like the extent of multi-homing, as I've explored in my research. Platforms can reshape the competitive structures in adjacent markets through their decisions. And so recognizing these common patterns of behavior and spelling out clearly and unambiguously how the policies apply there is a priority. Another example where spelling things out more clearly can avoid confusion is when we think about monopsony and monopsony power. and particularly market power with labor markets. That's a passion for many of us at the DOJ Antitrust Division under the leadership of Principal Dagdo Ameki and Principal Economist Ioana Marinescu. It's basic economics to observe that market power leads to reduced incentives for output. If something happens to increase the market power for labor, it's Econ 101 that a firm would buy less labor, produce less output. That's bad for labor, bad for consumers, bad for allocative efficiency. And also, suppressing demand for labor interferes with the important signal to workers that this is an industry worth entering. For example, if wages for nurses are suppressed, we have fewer people going to nursing school, fewer people moving to the markets where there's a shortage, and that hurts workers and consumers. So, this we've already understand this, but it can still be the possibility for confusion, and just spelling it all out carefully and making sure that there's no smoke and mirrors on the way to applying the antitrust laws is really important. And by the way, you can see DOJ's focus on this in our enforcement and policy program, not just in our thinking about the guidelines, from Penguin Random House to our consent decrees in poultry, our robust work on no poach agreements, our statement of interest in recent cases involving MLB and the NCAA. And, if you look at the Penguin Random House specifically, that reflects some of our thinking. The merger would have diminished the breadth, depth, and diversity of stories and ideas and decreased author compensation. So, exercising market power in the labor markets can really interfere with getting the right resources, the right innovation to the right place. Finally, just in the spirit of understanding market realities, we need to think about market definition more realistically. Here, actually, the 2010 guidelines address this problem very precisely, but somehow, we can still end up spending way too much time arguing about these false narratives about there being one true market or having like the battle of the markets. The courts have long been clear that antitrust markets don't have precise metes and bounds, but I think some confusion can arise because we need to make more clear why market definition can both be inherently fuzzy, as the courts have recognized, but also still reliably focus attention on the areas of competitive concern. And of course, part of the explanation is that there can naturally be many markets that all satisfy the criteria to be relevant antitrust markets. So it isn't surprising there isn't just one true boundary. In addition, with market definition, there's more work to do to make sure that the translation of these general ideas to common fact patterns is clear. We can have customer segmentation. We can have firms doing price discrimination. We can have firms that are some firms are selling bundles, other firms selling individual products. And all of that can possibly lead to confusion. And we just need to spell out how to apply market definition to these fact patterns that are increasingly commonly encountered. Finally, we want to just make sure that we are clear that market definition can also just follow directly from the facts. When we see firms competing directly head to head, we see direct evidence of market power. There's a market there. There's an antitrust market there. And the analytic lens should be appropriately focused on the areas of competitive overlaps or concerns as they appear from the facts. So just summarizing, it's a big project and there's lots to think about, but it's really important for us to make sure that this translation from the concepts to these important fact patterns is clear, and that we can really not argue about the concepts and really focus our attention in cases on proving out the facts and the evidence that meet these fact patterns. Thank you.
Thank you, Susan. And of course, the emphasis of the fetish of market definition is one that really is in so many ways something which is peculiarly, I think, US. In Europe, we have less of that, but it is something which is, I agree, a bit of significantly a distraction relative to understanding really the competitive dynamic, which is what the economic focus should be on. So I want to turn to Pierre, who has announced that he will say whatever he likes, and I will not be telling him what to say.
So you can stop there.
and so please comment on what you heard.
Yes, again, I'm going to say whatever I want. So the first thing I want to do is the rejoinder to what Susan and Aviv have said. When you're in the trench, you do not come from kind of broad ideas of where competition policy is going, whether it should be much more dynamic or something like this. You look at the fact of the cases at hand. And as Susan has pointed out, existing modern economic theory provides you with a wealth of tools to deal quite accurately with the specificities that you look at. Okay? So it's not to say that the greater discussions that we have about big trends, what we're getting wrong, killer acquisition and so on, are useless, but they certainly should not come at the expense of this careful case-by-case analysis that we do. Otherwise, in an attempt to make enforcement stronger and better, it's actually going to, in the end, discredit enforcement. So I think it's very important to do this. Let me exemplify this a little bit. And let's start with one of my least favorite concepts, which is the concept of killer acquisition. What's new about killer acquisition? Absolutely nothing. Why do we care about killer acquisition? Because that's removal of a competitive constraint. So is the fact that you're going to have a merger between firms with overlap, whether this affects price, quality, or R&D. This is exactly the same mechanism, the same first-order condition, just you in a corner rather than not in a corner. Why do we care about a corner? Why is it not a corner? I'm not sure. It's not new either. If you go back to 1982, Gilbert and Newberry, sleeping patents tell you exactly that. If I have a patent, this is kind of an entrant. If this is the new patent available, even if it's not as good as mine, I'm actually acquire it just to prevent the entrant from getting it. This is exactly the same mechanism. Okay? So we've made a fuss about something that conceptually is absolutely new, not new at all. Now, how useful is it? Well, if I'm in a situation like in Europe where I cannot go back and look exposed at mergers to change them, do I have any way of ex ante knowing whether it's a killer acquisition or not? Some people have invested in that. Kayuvekun is an interesting paper where he tried to put together different metrics to see, is this likely to be more of a killer acquisition or not? But we're very far from knowing how to do it. And also, even that, why should I care? All I care about is not whether it's going to be killer or not, it's whether it's going to be anti-competitive or not. And from that point of view also, people are not careful about what they call killer. A true killer is that it just kills a company bye-bye everywhere. But if you look at most cases, that's not what happens. There's a significant transfer of resources, personnel, know-how, assets, and so on. Then in that case, the fact that the killer acquisition is not in itself even a sufficient condition to say that it's not a good merger. So again, so far, what have I learned? Let's now look at the empirical work. Very good work by Cunningham and so on, who tell us that yes, there are killer acquisition in pharmaceutical. Sorry guys, but we knew that. Actually, not only we knew it, but we've been handling this in pharmaceutical merger for about 15 years. That's one aspect of their very careful study which is useful, is they find this cluster of killer acquisition just kind of below the thresholds, right? Now that's useful because it tells me that yes, there is a rationale for us to try to be able to intervene below those thresholds. That moves me to the next one. I think that the attention we've given to killer acquisition has been mistaken. What we really be worried about is much more what we are called early acquisition. And that's the kind of thing we see more in the tech sector. And these are acquiring small firms before we really know much about what they do, whether they're going to be substitute or complements for the... That, I think, really is what we are worried about. And again, that is not killer or not killer. It's the ability of trying to look at this early enough. And from that point of view, I'm very happy that the European Commission has tried to do this by kind of reciting an old interpretation of Article 22, so that we essentially can look at very, very small transactions. So that, I think, is the one thing that I learned from this whole saga, and I think we've dealt with that. Now, of course, when you start with early mergers, you face the problem of evidence and uncertainty. And that's something that we're going to have to be comfortable with, taking decision based on evidence which is not quite as rock solid as what we used to. But let's not just say, oh, it's a problem, it's too bad. Let's also work on finding ways of providing better evidence under condition of uncertainty. That's something that is really directly productive. If academic were to look at this, it would be directly useful to us. So I don't just say, oh, we're going to have to decrease the standard. I'm willing to do that. But let's also find out how we can do better. Okay. Second theme is going to be very short. Is this kind of conglomerate kind of mergers, right? Now, the problem that I have with that is that it leads some people and some authorities to extremely complicated theories of harms. And now suppose somebody with a cloud acquires a fridge maker. It's the greatest fridge makers on earth. And therefore they can, because these are smart fridges now, they can get the data reporting directly to their cloud. But maybe this data is only going to be able to be compatible with their cloud. And then accessible only with their some restricted browsers. And then might interact with the operating system dominance. And that can kind of feed back into the video game market. Okay? Well, I'm sorry. This is silly for two reasons. We already have problems, as I've just said, taking much more traditional theory of harm and applying them in a case where we have less evidence. Let's deal with this problem first before going crazy about the theory of harm. And also, I'm very alarmed that some of those theory of harms have been presented, even fairly recently, in framework where they say, oh, evidence, numerical evidence, we don't need numerical evidence. We just need to tell a good story. I'm sorry, no, especially when you've got this multiplication of you need step 1, 2, 3, 4, 5, and 6. The very least that you owe to the public and to the rule of law is to have some idea of the numerical importance of each of these effects so that you're at least talking about something concrete. Okay. Then finally, and this can be linked also to the notion of conglomerate mergers, there is an increasing rebirth that I see, both at the Commission and everywhere else, of thinking, oh, we've said that we don't like efficiency offense. But do we really like those big firms kind of getting better and marginalizing the others? Can't we find a way to get at them? First, there's a whole thing of trying an investigation to get at a company is something they don't really like. It should be an investigation, not an inquisition. Then, what does it mean? I mean, I'm not saying that the fact that a big incumbent gets better through a merger is necessarily innocuous. But when you think deeply about it, there are kind of only two main reasons why it might be so. Because it enables some kind of behavior you could not have before. For example, enable some kind of bundling, some kind of leveraging, or because essentially it enables foreclosure. The thing that makes you better is rare. There's some scarcity to it. And therefore, by acquiring it, you make it harder for others to compete. And then people say, no, but we don't need foreclosure. And the way it's usually phrased is that it's bad because it raises barriers to entry. That's foreclosure. They're saying, well, if there's no scarcity, everybody else can do it, therefore it doesn't raise the barriers to entry. So it's exactly the same thing as foreclosure. So as you see, that's why I'm maybe less enthusiastic about all the broad discussion about we need to be much tougher and so on, because in practice, in day-to-day cases, that lead part of the crowd involved in this to, a lowering of intellectual and evidentiary standard, which I don't think is warranted, however tough the problems that we think that we face are.
Okay, so I'm not going to fight with you, Pierre, but I don't agree with many of the things you said. One of the things I wanted to I wanted to, we've been together for 20 years, so we know each other. But so one of the things I wanted to just mention is that you're right, the expression killer acquisition is badly used because, of course, it is a very specific set of situations in which you buy someone to kill it. And it isn't something that happens in practice. Much more often, you see the acquisition of someone in order to effectively do something that you were going to do yourself, and you buy instead of building. And so there is that question, and we heard this discussion this morning as to whether that buying a nascent company to just essentially replace your own innovation effort is something that we are worried about. As someone who came up with the idea of reverse killer acquisition with Greg Crawford and Tommaso, I care about that, and I agree with you that that's a manifestation of a potential problem. Now, I want to go at this point to Sarah, who is the senior regulator in this. She is, of course, the CEO of the CMA, an agency which has certainly been moving the dial significantly globally, really, before you with Andrea, in terms of merger developments. MetaGiffy has been mentioned as a significant case. And of course, you are facing these questions about how to think about new theories, how to think about articulating these and defending them potentially in court every day. Do you want to give us a view?
Thanks, Christian. I'd love to. I have the unenviable privilege of being both the last participant and the only non-economist on the panel, but I'll do my very best. So look, I think it's been, well, firstly, just to say thank you again, as others have said, but it's been a fascinating discussion today. Before I sort of offer some reflections from the CMA's perspective in terms of how many of the themes that we've heard discussed, I think, in this session are sort of playing through already in the work that we're doing, the approach that we're taking, I did just want to offer a couple of sort of broader thoughts because I think we've had a lot of discussion today about sort of positioning, repositioning. It's also, I think, really important that we're very clear about what our position is and are clear that the narrative that we give can be sort of played back in the wrong way to us as well. So, for example, I think it's sometimes played back to us that the CMA is simply anti-mergers. And that's not the case. We will look at each merger on its facts, as we've all discussed through the day. And there will be mergers. And the fascinating chart from Bruno maybe showed that there will be mergers that take place between firms in competitive markets, and those mergers can deliver benefits. Those aren't the problematic mergers that we're discussing today, and I'm not going to focus on those, but I do think it's just important to be clear that we are not in a world where we are saying every single merger is by definition a problem. But what we are concerned about, obviously, is mergers that give rise to market power, consolidate market power, can entrench that position, can extend that position potentially into adjacent markets as well. And that's where we're going to have a real concern. And those are the issues that we're all grappling with, the best way to tackle. Now, I think Christina mentioned earlier on in the panel the sort of debate on under-enforcement is sort of well trodden and to some extent, I think, now well understood. And I think from the CMA's perspective, we've certainly been on an evolution over the last few years in terms of how we apply our approach to merger control, particularly in the markets that we've all been discussing today, particularly in those sort of rapidly evolving digital markets, tech markets, and others with similar characteristics. And a sort of turning point, certainly from our perspective, were the reports that came out back in 2019 from Furman, from the Lear report that we had commissioned in the UK as well, which really did provide that clear evidence of under-enforcement. And I think that was really important because it goes back to this point about having concrete evidence to base our approach on. And that really sort of shone a light, I think, on two aspects. The first of which was, and we've been discussing this at length, but we need the right analytical framework. We need the right theories of harm to apply to the kinds of markets that we're seeing these mergers taking place in. And I'll come back to that. And the second was that the point about uncertainty and unpredictability. We know that, by definition, merger control is a forward-looking analysis, and particularly in markets where there are rapid changes, where you're dealing with nascent competitors, where you're dealing with evolving technologies, where you're dealing with, an inherent degree of unpredictability. We need to make sure that that uncertainty in and of itself doesn't become a bar to effective merger control. And those two sort of key learnings, I think, were absolutely critical in shaping the way that the CMAs evolves our approach to merger control in those markets. So what has that meant for us in practice? I mean, I'm sure many of you will be familiar. Susan was talking about the guidelines in the US. In the UK, we updated our merger assessment guidelines back in 2021, and we included a number of themes in that, very much picking up on many of the points that have been discussed in this panel today. So one of those was, as Kira's been mentioning, a sort of specific discussion that we had in the guidelines, but also reflected in a number of our cases, really drawing out the importance of looking at both potential competition and dynamic competition and how that plays through in merger control. And the Facebook Giphy case, the Meta Giphy case, was an excellent example of that, where we took the analysis in that market and we saw the concerns around dynamic competition, around the possibility not just of future competitive constraints, but the fact that a nascent competitor at that point in time could be creating conditions of competition, both through their own innovative activity, but also through the sort of playback effect that had on the incumbent. And that was the essence of a core sort of focus of that case. And actually, I think it's an important one to call out, because you talked earlier in the day about the interaction between enforcement by agencies and by the courts, but that decision was upheld by the Competition Appeal Tribunal in the UK, which sort of reinforced not only the outcome in that particular case, but the approach that we'd set out in our guidance. And that, I think, has been a really important moment for merger control, not just in the UK, but more broadly. So a clear focus there on potential competition and dynamic competition, how that plays through. We've also focused a lot, this picks up many of the themes that Susan mentioned, the work that's happening in the US, but we've picked up a greater focus on how we look at mergers in relation to innovation, as I say, how we pick up themes around uncertainty, and all of this. And I think this is where, for me as an economist by undergraduate experience only, but as a lawyer working in this environment and now as the head of the agency, I can't emphasize enough how important it is that the analysis that we do is connected to, is grounded in the commercial reality of the markets that we're looking at and the businesses that we're dealing with. And I think, I find the debates fascinating and quite frankly, quite enjoy being able to be a little bit outside of some of the debates around the sort of the approach on the econ side. But I think the simple truth for me is that we've got to have an economic framework that maps across to that commercial reality. And I don't think it's very much more complicated than that. And when we get into debates about, whether we're looking at vertical, horizontal, conglomerate, flywheel, ecosystem theories of harm, I'm not sure it matters too much what the label is that we're giving to that. At the end of the day, what matters is, as agencies, we understand the dynamics of competition in the market, that we then need to look very carefully at how that merger is playing through. And many of the themes that Jonathan mentioned in his speech earlier, we mustn't take a static approach to this. We must understand the context of the market. We must understand the way that the market may evolve and look at how that merger will impact on those dynamics. And I think also as an agency, we just need to be comfortable that there will be a degree of inherent uncertainty in that analysis. And to Avi's point, we will get the analysis that we can. We will take the evidence, whether that's evidence from the companies, whether that's evidence on the transaction value, which I think is a really important indicator for us to consider, whether it is the economic analysis that we can undertake. But at the end of the day, we can only take our decisions based on all of that available evidence, and then we have to take a decision that in our case, in the UK, is on the balance of probabilities and involves inherently a degree of judgment. And we have to be comfortable with that. And I think that is a fundamental learning that we have absorbed as an agency over the last few years, that we cannot allow the sort of lack of complete knowledge and the lack of complete certainty to prevent us from taking effective merger control decisions. And frankly, that may mean that on the margins, sometimes we get it right, sometimes we get it wrong, because it is not a precise science. But we have to be comfortable working in that framework. And I would hope that that's something that sort of plays through when our cases are also tested then in court. But I do think that explains also why we will have a much greater focus, also to some of the points that were raised in the earlier discussion, on, for example, if you've got a company with significant market power buying up a nascent competitor, you will have some uncertainty about how that market is going to play out. But you do not, to Pierre's point, you do not have the ability to unpick that. And there is a responsibility on us as agencies to step in those circumstances. But I just want to emphasize that in doing that, we will take a measured approach, we will take an evidence-based approach, and we will take an objective judgment. It is not that we are on some kind of ideological mission that we will block any transaction, come what may. But it is important that we do it in a way that is grounded in commercial reality, that understands that and does the very best that we can do to fulfill our duty and our responsibility to make the right judgments about whether those transactions are going to impact on competition. The only other point, Christine, I thought I'd mention just in passing, because it came up much earlier today in relation to Barry Lynn, I think, mentioned around sort of resilience. And I think that the sort of interplay between merger control and resilience can also be an interesting one. I've thought quite a bit about this, and I don't think that you need a separate lens to look at resilience when you're thinking about merger control. But I think when you're looking at sustaining competitive markets, sustaining plurality of supply, in a number of cases, you will be playing through exactly the same kind of considerations that you would want to when you're looking to make sure and ensure that markets sustain that resilience, that retain that plurality of supply. And I think that's something that we should be willing to be more explicit about when we're considering those sorts of issues in merger control contexts as well.
Wonderful. Thank you so much, Sarah. These are very good points. I don't want to detain. I'd love to have a second round with everybody, but we don't have time. I think it is fascinating to listen to this discussion. I don't move away from the point that I think that on average overall in the last 20 years we've under-enforced. This is my view. It is shared by many. Many can still say, but we've done it. There's nothing new in what you're telling us, maybe, but we've not used it very effectively so far, and this is why we are where we are. We cannot say that we do not see evidence of it. It's all around us. It's the discussion this morning. So it's not that one has got no idea about how to do it better. It's complicated, I get it, but what is the benchmark we should adopt? That's the discussion to be had. And again, I want to avoid everybody taking away the notion that somehow, there is economics and it's the right way of doing things, and somehow there is the rabble over here saying, no, we don't want any economics. It isn't like that. It is just we don't want, there is a sense that some of the economics that has come to pass in cases is being beside the point, over-elaborate, not that useful. And so the call for simplicity is a call for mapping into the business reality, really, which isn't devoid of economics. It's precisely about economics, what the economics of businesses really mean. So I'll leave it here because I don't want to speechify myself. So thank you so much to the panel. Join me in thanking them. And we are running late, but I think we deserve to grab a coffee before we have the final stretch. Thank you.